that the application be certified fit for hearing before an expanded court as provided for under Article 1654 of the Constitution, and the said court be appointed by the Chief Justice as decreed under the Constitution. My Lord, on the 5th of March, the Peace Court issued directions on the application now before you. We said at the outset that a single judge of the High Court has jurisdiction to hear and determine any constitutional petition that may be presented before court. The singular distinction, however, my Lord, in the third petitioner's petition is the wording in Article 1654 of the Constitution, Article 1654 of the Constitution, to the effect that if a matter is certified as raising a substantial question of law under clause 3B or D, it shall be heard by an uneven number of judges, being not less than 3, assigned by the CJ. My Lord, what does the provision in 3B and C respect to? It is that the court has jurisdiction to determine the question of whether a right or fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened, or in D, particularly D, Roman 2, the question as to whether anything said to be done under the authority of the Constitution or any law is inconsistent with or in contravention of the Constitution. My Lord, the issue, therefore, that lies before you for determination is what is a substantial question of law under Article 165, sub-Article 3B and D2. My Lord, the petition now before you, the third petitioner's petition, particularly is what I talk about, seeks an answer as to whether Article 168 of the Constitution permits an omnibus petition for the removal of an entire bench, in this case of the Supreme Court. The petition also raises questions as to whether the JSC may entertain a complaint with respect to a challenge on the decision or independence of the judge. Further, my Lord, the third petitioner's petition further raises questions as to whether the JSC is mandated to entertain a petition which seeks a merit review of a judge's decision. When you look through the petition, the thread running through it, my Lord, holds together the complaint as to whether the JSC, upon receipt of a complaint, is under a legal duty to conduct a preliminary review of the complaint before it may even desire of a judge to respond to it. In other words, is the JSC merely a conveyor belt for complaints raised against judges? I have looked at the response by the JSC, an affidavit by Winfrida Makaya, in which she sets out, and I refer here to paragraph 24 and 28. My Lord will look at those paragraphs in Winfrida Makaya's affidavit, where she sets out an elaborate system of how the JSC handles complaints against judges. But that is a formal state of affairs. When you look at the Dari petition, to which the JSC requires the third petitioner, Justice Lenaola, to respond, paragraph 4, my Lord, of Raphael Tuju's affidavit states clearly that Justice Lenaola was not part of the bench that had the matter which gives rise to his complaint. What does the JSC do? They get the complaint, they do an elaborate letter to Justice Lenaola and tell him answer to these complaints. Yet, the complainant himself has said Justice Lenaola was not party to the bench that determined his suit. What does this indicate? It indicates that it indicates a monumental failure that the JSC do not even read the complaints that have been placed before them. All they do is receive and deliver to the judges. My Lord, you will see in paragraph 8, that is on page 10 of the petition, a long litany of ongoing litigation with respect to the complaints now before the JSC. The constitutional question then is it permissible for the JSC to entertain complaints based on matters before the courts? And we have listed a long list of complaints. I don't want to go them, go around the list, but you will see paragraph 8, page 10 of our petition, a long list of cases that are before different courts, including the East African Court. How then does it happen that the JSC permits the same matters before court to be the subject of a complaint to which they require a judge to respond? Lord, finally we sit around the question, what is a substantial question of law which may necessitate an expanded bench as provided for under Article 165, sub-Article 4. My Lord, time and again, the Constitutional Court has answered this question in different words. We don't need to bother you with the list of authorities. They are provided before you.